Kaya Biz
with Gugulethu Mfuphi.
On the street, on the air.
On Kaya 959.
Indeed, you're listening to Kaya Biz on Kaya 959. And of course, we're going to talk all things legally speaking right now, specifically related to contracts. If you know anything about a contract, it's legally binding. It's an agreement. There are several aspects of a contract that actually make it a viable document that is respected and, of course, acknowledged from a legal point of view. But how does one prove that they might have had to sign a contract under duress or perhaps were tricked to do so? And this often happens in various circumstances, right? Where perhaps you're made to sign a document and you're not aware. Perhaps you're made to sign a document without raising your concerns and grievances to some of the terms and conditions that are present. What do you do and how do you manage that particular dispute?
Legally speaking on Kaya Biz.
Well, to help us answer those questions in a moment, we'll be joined by the founder of Motalane Attorneys, that's Mojalefa Motalane, who'll join us on the show this evening to address exactly this particular matter as to how best entrepreneurs, individuals in their personal capacities and loved ones need to manage having signed contracts, perhaps without the full and clear understanding. What's also important that we need to be mindful of is that not only do or can contracts be signed under duress, but at times we also find ourselves perhaps not fully reading the terms and conditions of particular contracts. And just think about the number of times you accept terms and conditions on your cell phone when you download the latest app, when you upgrade your software, when you perhaps even log onto a website and all they're telling you is accept cookies to continue, and you haven't fully read and understood what detail of the cookies or the intricacies of the cookies that they are looking to extrapolate from you. Or even just your insurance contract. Right? How many of us have not taken out the time to read terms and conditions that exist? So share your thoughts with us, because that in itself is a binding legal document. It speaks to a contractual agreement and arrangement, but you do need to be cognizant of that detail, what it entails and how it will likely impact you and your further business operations. So do keep in touch with us and let us know if you're able to share any details of having previously signed contracts under duress, and if you struggled in terms of managing some of the conflict that does arise from that. How do you manage it? Who do you speak to? How do you raise your concerns? And most importantly, even proving that you might have been tricked or signed a contract under duress. As mentioned, my guest this evening is Mojalefa Motalane, founder of Motalane Attorneys. Mojalefa, welcome to the show and thank you for your time.
Hi, good evening.
Awesome. Great to have you with us. I guess first things first, Mojalefa, let's go back to the basics of understanding a contract, right? That it's binding within various aspects. And first thing that comes to mind when anyone thinks of a contract is that, hold on, this is a mutual agreement. This paperwork that we're agreeing to is what we both want as key and interested parties. Take us back to, I guess, the legal understanding and the legal foundation of contracts and what makes them binding.
Yeah. So, in fact, you've just actually mentioned one of the primary requirements for what is called the essentialia of a contract, meaning these are the essential terms that the parties, agree on in order for a contract to be a valid contract. Mm-hmm. So the first one is that there must be mutual consent. So the parties need to, in principle, agree what is it that they're actually contracting about. So that's the mutual consent aspect. Secondly, there has to be a valid offer of some sort. So you're buying a property, you're buying a company, or a car. So effectively, that fulfills the requirement for there to be a valid offer between the parties. And there must be acceptance. So meaning that the one party who's selling to the other has to basically accept the terms of that agreement. And on that basis, then there's an understanding of what the agreement is about. Then fourthly, there's basically what is called adequate consideration, meaning how much are you actually paying for something. So in most instances, contracts are about buying or selling of things. So there has to be a consideration that is paid, for whatever the two parties are contracting about. And most importantly, there also has to be authority. So the parties have to have the necessary capacity to be able to enter into that particular contract. So that's one of the things, for instance, as part of the subject of this discussion, tends to become an issue where people do not necessarily have the authority to enter into a contract that, they are pursuing. And lastly, the contract has to be legal. So you know that as a country, for instance, in South Africa, all our laws are subject to the Constitution. So meaning that the contract itself, has to meet, the legal master of the Constitution, which includes Bill of Rights and so forth, including any other relevant aspect of the Constitution. So legality is the also important principle around this.
Got you. Let's talk about signing a contract potentially under duress and the various circumstances within which or how this could potentially happen.
Well, duress, as the word explains, a person may be, forced, or pressured to enter into an agreement that they may actually not be comfortable with. This tends to happen a lot, also where in instances, if both parties' intentions may not necessarily, be bona fide, intentions. And therefore, the one party pressures the other one, to enter into a contract. So you'd find, for instance, people say, oh, look, please sign as soon as possible, without necessarily giving people an opportunity to consider the signing of a contract, meaning to consider all the relevant terms that they actually comply with the aspects that the parties, are contracting about. You also find now, which is quite a positive thing, that there are certain clauses which are called cooling off periods, where, for instance, if a person, enters into an agreement and, a few days later they change their mind, they would have at least had a period to consider, what actually options they have. But duress in its classical, definition is basically being forced to sign an agreement without you being comfortable to do it.
Got you on that one. And I think that's the duress is one aspect. And as you say, another could just actually be signing a contract and without your knowledge, forged signatures and someone perhaps imitating your and assuming your identity. How would that particular circumstance be managed?
So there's a lot of identity fraud generally that takes place. And I think that would be, how generally this kind of thing may happen, which effectively, would be fraud. You remember back in the day when there were checks and people, used to sign checks, and which is one of the reasons why checks were sort of phased out, was because there would be a lot of forgery of people's, signatures. And then to cash their check, So in contract, it's very possible as well for people to to find themselves, because their identities have been stolen, that they are now contracted to people that they've never met or they don't know anything about. So that is in the realm of criminal. Basically action where a person is committing fraud, because they are then forging your signature, whether, for a contract or, to take credit in your name or whatever the case may be.
Ooh, and this is the one that you need to prove, right? Because it's one thing for me to come to you, Mojalefa, and say, hey, I'm not the person who signed this contract, but at some point you need me to substantiate that, right? With a sense of proof and validation and clarity. But help us understand how one would have to manage that kind of scenario.
Yeah, it's a very difficult one. It's a very difficult one, but unfortunately, if a person finds themselves in that kind of situation, you would then have to, provide some kind of proof to show that actually, you are not the person that entered into that agreement. I would presume that you would also have to, file a statement with the police, which, probably would also be a requirement, depending on the nature of the contract. I mean, a lot of this situation usually, happens with credit agreements, where people probably, take credit, without a person's consent, and so money would have then, been exchanged. And so, that particular company may be obviously trying to recoup the money that they lost. And therefore, trying to bind you into that agreement, even though you are not the person who are responsible for it. Yeah. So, as I said, it's a pure criminal act. And obviously a case would also then have to be opened in that kind of situation. So that would, in my view, be sufficient for a creditor or whoever is not sure about who exactly is the real person that they may have contracted with. Gotcha. And I presume then they would have to take some other kind of recourse. But I know there are situations where people have had to go to ombudsmen, in various sectors because they have been, placed in agreements that, they don't know anything about. And our law, unfortunately, in most instances, is not rather unfortunate, but, it's meant to protect parties. For example, if you do enter into an agreement, a contract cannot just simply be, amended or varied, without the parties agreeing to it. Which is called the chevron clause. So it's a protective mechanism. So if you are in a contract and you are disputing the validity of that contract, you will then, have to show that actually you are either under duress or it's a misrepresentation, which is something that can nullify an agreement. The fact that there was a misrepresentation, one party either misled the other party or your identity was misrepresented, and therefore you entered into that agreement without your knowledge or consent.
Got you. And I think this is so important. If you've just joined us, we are in conversation with Mojalefa Motalane, founder of Motalane Attorneys, giving us some insight into how to manage any discrepancies you might have with a contract. If it's signed without your understanding, you need to understand that there are basic elements that make a contract valid, right? Understanding the various ways within which a dispute might occur. Either signing under duress, which is force or pressure, or perhaps even being misrepresented where it's not your signature, that you haven't signed it in person. However, someone has forged your identity and represented themselves to be you. And you mentioned a very important point, Mojalefa. You actually spoke about it as a particular clause that exists should there be alterations to the contract. And this, I can imagine, is a very important one, especially for entrepreneurs or individuals in their personal capacities, where we agree on one thing, that I'm selling you a car, it's green, it's for this value, this is the agreement, and then later on I end up adding that, oh, by the way, it's footstoots. Help us understand how to manage any changes or alterations that would be required on a contract and modifications there, and the process to manage that effectively.
Yes. So earlier we touched on the essentials of a contract, which are the requirements for a contract to be valid. There's also what is called the naturalia of a contract, which are the natural terms of an agreement, depending on what the parties are contracting for. So depending on what type of agreement you are entering into, it will then have specific clauses relevant to that type of agreement. There's then other clauses which are incidental. And the non-variation clause is one such clause that basically, is now has become a standard clause in South Africa. I think following the Chevron case in 1964, that confirmed basically that there's an entrenched principle in South African law that if parties are going to change the terms of an agreement, those parties have to then follow certain processes.
Okay.
Ordinarily, those changes must be in writing. The parties must have discussed and, have both agreed and understood what the changes of those agreements, are or entail. And therefore, it then, protects both parties to ensure that there is no, party that can just simply basically wake up and change the terms of an agreement without the other party consenting to it, and that type of amendment being reduced in writing.
Got you. It needs to be reduced. And it needs to be, as you say again, reduced in writing, an acknowledgement by both parties. And we both need to agree, right? It's
Yes.
It has to be a quid pro quo relationship. Mojalefa, I can imagine there must be many disputes that you must come across, right? Whether in the workplace, entrepreneurs with their business dealings from a labor point of view. But typically, what are the mistakes that you find, or are people vindictive? I always believe in the good of people, hey? But I guess when it comes to law, you deal with facts. But are there, I guess, typical mistakes, typical errors that folks need to be mindful of and a little bit more cognizant of? Even as basic as reading the contract and its detail. I'm aware that a lot of us don't do that when it does come to certain products or services that we look to acquire.
Yeah, that's it. I mean, the first mistake, a lot of people tend to do is that they tend not to read the agreement. Yes, there may be certain clauses of a legal technical nature that may be complex, but the essentials of an agreement, are actually the most important basic things. What is it that you are agreeing about? Are you selling a car? Are you satisfied that this car suits your requirements in terms of its condition, its price, and therefore, I'm going to pay X amount of money for that car. That's it. So those are, in principle, if people, are able to be clear as to what is it that they agree on in principle, then the rest becomes easy. It also makes the drafting, of the contract quite easy because the parties would have agreed. But yes, sometimes, in fact, a lot of times it happens that even though parties have agreed, some people just simply, for one reason or another, decide to unilaterally, either divert from the agreed terms, or they just simply do not want to perform as they had agreed in terms of the contract, or they just simply don't want to pay, what they had agreed to. So that's why, therefore, it's important for people to understand that once you have entered into an agreement, it's a binding agreement.
Yep.
And it's merely an appreciation of the fact that it is the way that, people have agreed that that's how things are going to function. If we enter into agreements and we do not respect the terms of those agreements, then society, basically, as we know it, would not be able to function, because it means that people can just simply, change contractual terms at a whim, as and when they feel like it, and that cannot necessarily be the case. And hence that's why the disputes end up, in courts. Other essential parts of an agreement is to make sure that there are sufficient, protective measures in terms of the kind of recourse that, a party can take. So ordinarily there would be, arbitration clauses in the agreement because, court processes may be expensive. but an arbitration process can enable the parties to discuss, through a mediation process if there's a misunderstanding or there's a dispute, that may end up in arbitration ultimately if it has to be resolved. But you may find that there are some instances where they are of an urgent nature because of the nature of the agreement, and therefore it is always important as well to ensure that the contract has what is called a specific performance clause to ensure that if one party does not perform in terms of the agreement, the other party is entitled, notwithstanding the arbitration process, to approach a court of law in an urgent basis to request the court to assist that the other party simply does what they have committed to do in terms of the agreement. Definitely. And fortunately, our courts, recognize that principle and ordinarily would agree and find in favor of a party that, has got a legitimate claim of specific performance against another party.
Got you on that one. Mojalefa, thank you so much for your time this evening, sir, and helping us navigate, the intricacies of all things legalese. Sometimes it's intimidating for many, but you've helped us understand how one can prove if they have been tricked, misrepresented, or signed a contract under duress, and essentially managing those disputes effectively. But it always goes back to, number one, mutual agreement, understanding the 7 conditions that you highlighted that do speak to having a valid contract, and managing those disputes effectively through adequate communication and understanding what it is that you're signing. Thanks again for your time this evening, Mojalefa.
Thanks for having me. Thank you.
Fantastic. That's Mojalefa Motalane, founder of Motalane Attorneys, joining us this evening on Legally Speaking.
Kaya Biz with Gugulethu Mfuphi, Monday to Thursday, 6 to 8 p.m. on Kaya 959.
On the streets, on the air.